Bank account beneficiary designations and account structure play a crucial role in your estate plan. Today, I want to discuss the importance of carefully structuring your beneficiary designations and account structure, and some of the most common mistakes I see people make. I'm Jennifer Nichols, estate planning attorney and founder of J. Nichols Law. I help Texas families make smart, secure decisions about their futures. Point 1. Beneficiary designations trump your will. First, it's important to know that beneficiary designations, such as POD or payable on death, override whatever your will says. That means that if your will says your assets are to be split evenly among your children, but your account designation only lists one child as the beneficiary, that one child will receive all the assets no matter what your will says. Point 2. Understanding the limitations of beneficiary designations. Beneficiary designations can seem like a quick and easy way to avoid probate, but they come with some big limitations. They are not flexible for minors. You can't, or shouldn't, name a minor as a beneficiary. Banks won't release funds to a child, and it can create a legal mess. There are no custom percentages. Most banks won't let you split the account among multiple people in different percentages. There is no per stirpes distribution. If one beneficiary dies before you, their share goes to the other living beneficiaries, not to their children. So your grandkids could be unintentionally left out. Point 3. The importance of proper structuring. Having beneficiary designations for your bank accounts is not a bad thing, and I often encourage clients to have them. However, it is important that you make informed decisions when making your designations and that they align with your overall estate plan. Let's talk about some real-life mistakes that I see all the time. First is adding a child as a joint owner. A lot of parents add one child as a joint owner on their bank account just to help pay bills. But here's the catch. When you pass away, that account automatically becomes that child's property. This is the case even if your will says your assets should be split evenly among all of your kids. So, what should you do instead? You could add your child as a signer on the account if your bank allows it, or you could name your child as your agent under a statutory durable power of attorney. That way, they can help you manage your finances without accidentally disinheriting your other kids. The second mistake I see is adding the executor as the sole beneficiary. Some people name the child they've chosen as their executor as the only beneficiary on their account, thinking that they'll split it up among their siblings. But legally, that money is theirs alone. They have no legal obligation to share it, and your will is bypassed. The third mistake I see is failing to update your beneficiary designations after a beneficiary dies. Here's a real example I recently encountered in my practice. A mother named both of her children as beneficiaries of her bank accounts. Her son passed away, survived by 3 kids. The mother never changed her beneficiary designations, so when she died, all of her money went to her one surviving child. Her grandkids from her deceased son got nothing. How could this have been avoided? She could have updated her beneficiary designations after her son died to name her estate as the beneficiary. That way her will, which provided for the grandchildren, would have controlled the distribution of the account. Had she done this, her grandchildren would have inherited her deceased son's share. Here are some final tips. Review your accounts regularly. Life changes, so should your beneficiary designations. Talk to an estate planning attorney. We can help you structure your accounts and your designations to fit your wishes and to avoid unintended consequences. Ensuring your beneficiary designations are set up properly is one of the simplest but most powerful things you can do in your estate plan. Don't wait until it's too late. Review your beneficiary designations today, and if you need guidance, we are here to help. Call J. Nichols Law to schedule a consultation and make sure your estate plan is in the best shape possible. Please be sure to like and follow for more estate planning tips.